My Lords, together with my learned friends Patten and Danji for the appellants.
Thank you. I think it's customary for you to introduce everyone.
Yes, in fact, my Lord, and my learned friend Eric Ribaud, SC, together with my friend Sarah and Yves appear for the respondent, first respondent, and my learned friend James Gaffrey QC appears for the second respondent.
Thank you.
May I start, my Lord?
Yes, by all means.
My Lords, it is agreed that the appellant purchased 17 hectares of land from Medine Sugar Estate on the 23rd of December 2010. And prior to that, on the 23rd of September 2003, Medine had been granted an EIA license for a development of 348 residential lots on the spot which is now Beau. And Medine did apply for an extension of the EIA, which had lapsed after a certain period of time, on the 3rd of February 2009, and it was extended up to 2010. And on the 18th of August 2010, Medine applied for an extension, a further extension, which was not granted, and they were requested to apply for a fresh application.
If it's of any assistance, Mr. Sougier, we are very familiar with
Yes.
all of the facts.
Yes, all right. So I'll go straight to the points, my Lords.
Could we, I mean, I'm very familiar with the facts.
Indeed.
What I'm not so familiar with, it's very new to me, is the law. And it may be, I don't know when it's convenient, but as soon as you can, I'd like you to explain, if you may, what the relationship, how the statutory scheme works.
Yes.
We've got the Environmental Protection Act, but we also have alongside it the Town and Country Planning Act of 1954 and the Planning and Something Act of 2004. And I assume that getting an environmental license is not sufficient. You need to get your planning permission as well. Yes. But at the moment, I don't understand what the relationship is between the environmental impact legislation and the planning legislation. And indeed, I don't quite understand why we had this long inquiry in the tribunal, which seems to be dealing just with the environmental legislation, but not with the planning legislation.
Yes.
So, at some point, can you explain to me how the legislative scheme works? And another thing I haven't been able to work out is how much of the 2004 Act is actually in force. Because as far as I can see, certain of the provisions were brought into force in 2006, and early, including the national strategy, but also the local plan provision.
All right.
And I don't quite understand why we're still talking about outline development schemes after that Act. So I just need to get the shape of the thing.
Therefore, I'll go straight to the issues which are live before the court and before your lordships. Any specific issues, my learned friend Patten is the expert in planning, so if I can't really go into a point, my friend will take over.
Good. Thank you very much.
My Lord, therefore, the issues which are before your lordships, first of all, that is the buffer zone issue. This is why this is, I think, the most important part. And your lordships will find that it is at paragraphs 34, 35, and 36 of the Statement of Facts and Issues.
Yes.
At page 3658. Now, as the tribunal rightly pointed out, the thrust of the whole debate was essentially around this buffer zone. The appellant, or the connected issue, whether the existence of a buffer zone was blighted by the buffer zone within the zone. That is, what is the fate of the land falling within the settlement boundary, and I'll come to the definition of settlement boundary later on, but which falls also under the buffer zone. So there were two ways to look at it, either the very restrictive view or the very flexible way of looking at it, which was suggested by the appellants before the courts. Now, my lords, of course, the main issue was did the court grasp what was before?
Well, can we first identify the buffer zone and what its status is? As I understand it, the key plan at page 1581
Yes.
Is something called a development management map.
Yes.
But I've not been able to find anywhere which explains what the
Yes,
status of that is, how it was approved, and whether it has any statutory force at all.
First of all, that is the right map, is it?
It is, yes.
1581.
Yes, it is.
Thank you. Well, that's a start.
Right. Look, I think for us to go through this, we have to go through the planning instruments. That is the National Development Strategy, the PPGs, and the BROS, as it is called, the Black
Well,
River.
can't we just start? I mean, this map seems to be of central importance
It is.
because it's one that the Court of Appeal, Supreme Court, principally relied on. And so I think whatever else we do, it would be helpful to work out what its status is.
There's no label on it.
Yes. Yes, we are looking at, yes, at the map. Yes, my lords. So we've got this pink or purple sign, which is the site of UBP.
When was it approved, by whom, under what legislation?
This is what we get in 2006.
This map, which you tell us is the critical map, has no label on it at all.
Sorry, my lord?
It has no label on it. What is it? Who produced it? For what purpose? And under what act?
My lord, this is that the thing? Okay. This is the map which was produced before the tribunal.
Who drew it?
Who drew it? This is the Town and County Planning Board.
Yeah.
Thank
I
you.
mean, if it's any help, Miss Koo gave evidence
Yes.
about it at page 988 of the transcript.
Yes.
And she says that she talks about we having introduced it, which I assume was when she was working with the
Indeed.
ministry.
Indeed.
And she says we no longer court, this is page 988.
988. I'm sorry. Yes, my lord?
Towards the bottom, she says, let me now refer you to the 2006 Development Management Map. We no longer call it a strategy or a zoning map. We've introduced since 2006 a map which is called Development Management Map. It's not a prescriptive map.
Yes, indeed. Indeed.
Now, but she doesn't say, it sounds completely informal. The ministry does produce a plan, but the Supreme Court seemed to assume that it was part of the 2006 outline planning scheme,
Yes.
but they don't say how or why.
Yeah,
I think it's rather important for us to
it
establish.
is. I think that the Supreme Court, we do respect, my lords, they went through all the planning instruments, that
Yeah.
is, first of all, the NDS, if I may go through, because they went through certain policies, which I think they wrongly interpreted at the end of the day. So there are four policies.
And I understand that. I mean, I've read your case.
Yes.
But I really would like, if I don't mind, if there's someone who can tell me what the status of this map is, I think it would be very useful because it seems to be fundamental.
It is the map which was drawn in 2006, unless my friend can assist on that. It was drawn in 2006.
Yes, I know, but there's nothing in the statute, in any of the statutes that I can see, which authorises the production of something called a development management map. And Miss Koo simply refers to it having been produced, but she doesn't say that it had any statutory force. And so that's what we need to find out.
I assume it was produced under the BROS. If my friend can certainly, he was the one.
Yes, perhaps you can explain. Do take your seat for the moment, Mr. Rosier.
I think we have a hybrid system where we have the Town and Country Planning Act, which dates back to 1954,
Yes.
which is, similar to the old days here, the 1948
Yeah.
Act,
47.
where it was a map-based. And you've got a schedule at the back of the Town and Country Planning Act, which is called the schedule where matters concerning the outline scheme have to be included.
Can we have a look
So
at that?
it's the Town and Country Planning Act,
This is the 54 Act,
the 54 Act,
which is the end of volume, page 4006.
and the And your lordship would find that at section 11,
Yes.
there is preparation of outline schemes. And the outline schemes are prepared by the Town and Country Planning Board, which is a committee on its own under the aegis of the Minister of Housing. And there is a series of provisions
Yes.
where once the scheme is prepared, it is then put on deposit for public to make representations.
Yes.
And then it goes on a submission to the, for approval
Yeah.
to the President. Now, once that is done, under 14(3), no authority shall pass or approve any plan that contravenes the scheme. Now, we also have the Planning and Development Act, which talks of development plan, which is more the sort of post-68, if you were here, where they've moved on from the rigid
Yes.
map base to a more flexible
But for
system.
this area, they seem to have gone on producing schemes,
It is the scheme, but the
because
scheme...
we had one in 2011.
Yeah, but the scheme, if you see, it consists of a text with a map. And the wordings of the text, according to the scheme
Yes.
itself, if you look at the BROS,
Yes.
prevails over the map. And what Ms. Koo is saying, that
Well,
the map...
sorry, pause there.
Yeah, okay.
2 points. Well, one is, where do we find anything in the text which talks about this map? And second, where do we find anything which says that the words of the plan, the scheme,
Yeah.
prevail over the map?
The Town and Country Planning Act does not make any specific reference to a map.
Yeah.
If your lordship may kindly look at 11, subsection 2.
Yes.
Once there is this approval under subsection 1,
Yeah. Yeah. Well, 11.2 says it makes
scheme
provision for the
prepared in
matter.
the provision of section shall make provision for matters set out
Yeah.
in the first schedule,
Right.
or may make matters in second schedule, which are very much the
Yeah.
same. But the second schedule also for detailed
Yeah.
schemes. And if your lordship may look at the first schedule,
Page?
and there's this, yeah,
4024.
it's 4024. There are various parts where we talk of roads, buildings and other structure, etc. And that are the matters which must be contained in an outline scheme.
Yes.
And the Black River outline scheme have taken this matter not in the form of a map-based,
Yeah.
but in the form...
But, I mean, what are you leading up to the point? You need, obviously, you need a map to show.
Yeah, you need a map to show.
So it's customary for a map to accompany the scheme.
Yeah, accompany the scheme,
mean-
maps and diagrams and
I mean, it may be common ground that this map is part of the 2006 outline scheme and was approved with it. Now, if that's common ground, I don't know whether it is. Is that
Mr.
common?
Rebo?
Yes.
It is.
If that's common ground,
Let's move on from
well, then
that.
I think that
Very
takes
much
us somewhere.
I'm not sure.
what is not perhaps common ground is importance to be given to that map
No,
as forming part of an overall scheme.
but you
which contains-
said there's something somewhere which says that the words prevail over the map.
Yes, the text.
Where is that?
All right,
Sorry, just to finish that point off.
Your lordship would look at page 1990.
90,
1990.
Which volume is that?
Not really.
This is document AA, is it?
It'll be in volume 8.
Is this
Yeah,
the,
important.
is this the Black River outline scheme?
It's the Black River.
Is it?
Yes, my lord.
It is. Thank you. 1990, Black River outline scheme. So this is the text.
Yeah. Oh, here's the development management map. Yeah. I see. It says on page 1990, it refers to the development management map, and it has a note which says if there are any discrepancies or omissions between the maps and the text of the policies and proposals, then the provisions of the policies and proposals should prevail.
Right.
Is that what you're referring
That's what I'm
to?
referring to. You have a text section and you have a map section.
Yes.
And of course, all the policies and proposals are contained in the text section.
Yeah.
The map assists.
So what does the text say about the buffer zone?
Well, we'll come to that.
Oh, all right.
Can we? I'm just trying to get the structure. I'm sorry. Just one last question, and you're being very helpful, Mr. Patton. Once you've got your environmental license, what then happens? You have to go back and get a planning permission, do you?
The system for Mont-Selma has been such that by practice, once you get the EIA license for undertakings, which qualify to have an EIA license first, once you get the EIA license, then there is the Mont-Selma Act, which comes into play.
Yeah.
Yes.
And after the EIA license has been granted, then the applicant, the developer, must apply under the Mont-Selma Act, which is
Yes. Well, we've got that.
Yeah.
Mont-Selma
Yeah.
Act.
So are you saying that one doesn't need to worry about the Planning Act at that stage?
At that stage, yeah, I'll explain once we get on the Mont-Selma Act. For subdivision of land, it is the Mont-Selma Act which ensures a sort of protection to, for example, buyers and those who want to occupy the land eventually. Because under the Mont-Selma Act, it's assumed that planning clearance has been obtained.
Yes. I see.
Because section... It's 4251, page 4251.
4251.
Yes, my lord. And if I may take your lordship to sections 5 and 6.
You say 4251?
No, is it 425 or 4251?
It's 4251 in volume 3. I suspect we haven't got it on the hard disk.
Which page are we looking for?
Oh, it's
It's tab 2, volume 3.
Page, please.
4251, but I don't think we've got it in electronic form.
I think that's the very last page.
We've got a thought.
Well, just give us the gist of it so that we
yeah.
can move on.
Under section 5, it says application for Mont-Selma permit. Every developer, it's on the 4252, my lords,
Yes.
at the bottom. Every developer shall make the application to the board for a Mont-Selma permit. And subsection 2, no person shall make an application under subsection 1 unless the proposed Mont-Selma is in conformity with the outline scheme or detail scheme in respect of the planning area.
And does it need to, and I see it has to be accompanied by an EIA license as well.
Yeah,
Yeah, I think I've got the gist of it. I think that's probably enough
entertain.
for the moment.
Thank you very much indeed.
And
That's very helpful.
And again, for the Mont-Selma Act, under the Mont-Selma, under section 6, it's 4254,
Yeah.
subsection 1, where after consideration of an application, the board, this is the Mont-Selma board, not the town planning board, the board is satisfied that the proposed Mont-Selma satisfies all planning requirements. So the Mont-Selma board would ensure from the local authority that the planning requirements are satisfied. And then the board shall forward the recommendation to the minister,
Yes.
and subsection 2, the minister, if he's satisfied with the recommendations of the board, will issue a letter of intent.
Yeah.
Well, I think we have the outline of the broad structure, and I think we should let Mr. Souzier
Yes.
resume.
If I may just complete that.
Yes.
Letter of intent, then the developer has 2 years to
Yeah.
get all the infrastructure right, and it is then that the Morselmo permit, after all infrastructure works have been completed to the satisfaction of the authorities, that the Morselmo permit is granted.
Yes.
Good.
Thank you very much.
Thank you very much indeed. Now, Mr. Souzier.
My Lord, so,
Thank you.
going back to where I was, the planning instruments that are of importance, there are 3 in fact. The first one being the National Development Strategy, the NDS, and your lordships will see that under section 12(2) of the Planning Development Act, the NDS prevails over any other planning instrument to the extent of any inconsistency. And this has been confirmed in the judgment of the Court of Appeal in Mauritius at page 3383 of the bundle. Now, at page 1735, it is volume 3, my lords,
Sorry, just give me the page number again, please.
1735.
173.
I'm dealing with, in fact, the NDS. Your lordships will see that
What document are we in, please?
document Z.
Well, yes, but what is it?
It is the National Development Strategy,
Thank
the
you.
first planning. Your lordships will see at page 735, paragraph 122. It reads as follows. The revised NPDP has been retitled the New National Development Strategy. It marks a change in direction and focus from the old-style plan-making process, which fixed on a prescriptive set of land use allocations. The new strategy is designed to be more flexible and dynamic in response to fast-changing requirements. So, my lords, this, I humbly submit, was not the line adopted by the Court of Appeal. They chose just the opposite. They went in the opposite direction by applying a strict and legalistic approach to all the documents or interpretations that they could make. If I may, my lords, as far as the NDS is concerned, this document Z, there are 4 policies. In fact, they made reference to 4 policies, the Court of Appeal. The first one being the housing chapter, the 5th bullet point. By the way, I do understand that it is not a policy, but it is an objective. And your lordships will see that at page 1816, document Z, 1816.
Yes.
This policy, your lordship will see at page 1815, under heading 5.5, residential land allocation. This is the title. And when we turn the page, the 5th bullet point reads as follows. It is down the page, 2/3 of the page. As a sensitive land use, new housing should not be permitted in close proximity to, that is, within 1 kilometer of bad neighbor developments, such as landfill sites, which would have a negative environmental impact on future residents, or on sites which would constrain future expansion of employment or leisure activities. This is the bullet point which is referred to by their lordships, by their ladyships. When we turn the page, under that chapter, you've got policy H1, which is residential land allocation. And A reading of this, of the heading, my lords, will show that the release of new sites for residential developments should follow a sequential approach. Subject to the provisions of policy H2, there will be a general presumption against proposals for new housing outside limits of permitted development. I stress on the words outside limits of permitted development, which is not the case as far as Songe is concerned, because we are within the limits of permitted development. So the application of that policy is wrong. I humbly submit to your lordships. Their leaderships were wrong to make any inference as to the effect of that specific policy. The second policy, which is referred to by the court, which has been considered by the court, is policy I7.
Sorry, just can I understand that? You're saying that by referring to the fifth bullet point
Yes.
on page 1816, they were, by implication, also referring to policy H1.
Indeed.
Is that right?
Indeed, my lord. And this policy doesn't apply to our case.
But the bullet points are surely dealing with residential land allocation
Indeed.
generally,
Yes.
but not specifically.
But when we look at H1, your lordships will see that it concerns outside the limit
Yes.
permitted.
But
So
they don't apply H1, do they?
they don't apply H1. They consider the housing chapter, the fifth bullet point. Is it to be taken with H1? Is it part of the same policy? So this is my view of it, my lord. I humbly submit that their lordships, their leaderships were wrong to apply because it doesn't concern Songe directly. The second policy is policy I7, which is in fact at page 1847 of this document, 1847.
Am I right, before you leave
Yes, my lord.
1817,
Yes, my lord?
that after the general statement under policy H1, the bullet points include the bad neighbour consideration at
Yes.
the fourth?
Yes.
Thank you.
Yes, of course. What I'm saying, my lord, is simply that it concerns whether it is within the settlement boundaries or not. This is because I think there is a different policy which is going to apply, and I will come back to this policy later on. Right. So this, of course, the whole issue is about bad neighbor industries and whatnot. The second policy...
I mean, the bullet points there, I think, are dealing with outside the settlements. Yeah.
Indeed. Yes. So,
Where's the policy which deals with housing inside the...
I'll come just in 2 minutes, my lord. I'm just making one by one the four policies.
1847.
Yeah.
1847 is the second policy which has been identified by the court, and it is policy I7. Now, my lord, this, once more, I would say that the court was wrong in interpreting that policy, because this specific policy, it concerns new sites, new bad neighbor sites. So we are not concerned with a new bad neighbor site. I think that once more they were wrong in applying this policy.
Yes.
My lord, the third policy is the one which applies to our case. And
it's a fair point, from your point of view, that their quotation of it omits the bit which talks about new sites.
indeed. Now, the third one is at page 1881. This is the important, I think this is the section which is of importance. This is policy NR2. Now, if I may read the heading at page 1881, to identify buffer zones around existing and proposed rock quarries and crushing plants up to 1 kilometer. I think that this, the crux of the case is whether it was a prescribed 1 kilometer or it was up to 1 kilometer. So our case is that it should have been flexible up to 1, and my learned friend's case is that it was prescribed, it was 1 kilometer. I think that all the readings have been through, that is whether it be NDS, PPGs and the BROS, there is the element of flexibility, which was not taken care of by the court, and which should have been taken care of by the court, which was taken care of by the tribunal.
But I mean, this is the general policy under the NDS.
Yes.
And it goes on to say the precise extent is to be determined in revised local plans, which I assume in this context means the outline scheme.
This is important, my lords, because, my lord, it has been suggested in our written case, in fact, this very point. It is at page 3667 and 3668, paragraphs 24, 25, that there is an onus on the Town and Country Planning Board to consult with the Ministry of Environment for the defining of the precise extent of the buffer zones. This has never been done.
Well, you say that, but we've got I think we're agreed that we have an approved scheme which includes a development map showing a buffer zone.
Yes, but your lordship will see, what we are saying is that this dotted line, this 1 kilometer, is not prescribed. Because there is no there has been no scientific, this has been subject of the debate before the tribunal. Yeah. There has been no scientific study which has ever been made, because your lordships will see, when we look at the evidence of Ms. Koo, I think, it is at page 989, your lordships will see that in all the stone crushing plants, there are a number of crushing plants which have been listed. Your lordships will see that the evidence says that there was a dotted line of 1 kilometer all around these. It was an arbitrary, as we call, irrespective of the nature of the site. Crushing plant, 1 kilometer. And your lordships will see at page 989, I think it is in volume 2, that Miss Koo, in fact, did, what, 989, yes. My lord, you will see that she makes reference to a number of crushing plants in Mauritius.
Which page are you referring to?
989.
Yes, she refers to Beau,
which is 240. You've got the dotted 1 kilometer. Beau is 240. You've got Plaine Magnan, which is 350. You've got La Laura, which is 400. You've got Fond du Sac, which is 550, and Saint-Julien, which is 500.
Sorry, where are you reading from now?
989.
989, my lord.
Line 20.
Volume 4.
It is line 20.
I'm sorry, I'm still trying to catch up with my EU version.
Why haven't
So
you?
your point, Mr. Chauzier, is that the 1 kilometer buffer zone is indicative, and it is not prescriptive.
Prescriptive, yes. Mm-hmm. This is the case that we have today. It is purely indicative, and the tribunal or the board has to apply its mind to all the pluses and the minuses.
Well, hang on. What she's saying at line 20 is that there are various housing settlements which are in fact closer to rock crushing plants than 1 kilometre.
Yes.
So what?
This is our case. We are.
Why does that alter the planning requirement on derived from this map?
No. What we are saying, my lord, is that the interpretation of the buffer zone is of major importance. What we say that this dotted line, you've got a great number of examples all around the place in Mauritius where you have housing developments within the 1 kilometer.
Well, were those developments which had a 1 kilometre dotted line around them? Were those developments, did those rock crushing plants have a 1 kilometre buffer zone shown on their maps?
Yes, this is
Where does she say that? Because it's not at line 20. You may be right, but what she says at line 20 is not that. She says that the houses are in fact closer.
Within, yes, within.
Yes, but that's not the same thing as saying that there's a buffer zone which has been ignored.
I'll answer that, my lord, yes, because it is somewhere in the notes where there is the dotted line all around all the crusher. I might be wrong, but.
Well, your case is that in each of these instances that Ms. Koo refers to, there was a 1 kilometre indicative line.
Yes,
But notwithstanding the existence of that, in fact, developments took place.
indeed.
It may be line 35, 36 on the same page, but I don't know.
Yes, you will always see the UBP site, the stone crushing site, and then the 1 kilometer radius and the built-up zones. For the Beau site, you can see near, there was a lot of debate around Beau, which in fact is a gated property, which is at 240 meters from the crushing plant.
Well, in any event, that's your case.
This is my case, my lord.
Yeah. Let's move on.
Well, Cameron and I, you know, if you're making the point that there are equivalent maps which are part of the scheme, which show similar 1 kilometre diameters, well, unless that's common ground, I think it needs to be made good, but I mean, maybe later. But
She certainly seems to say that. If you turn the page to 990 and look at the first 5 or 6 lines,
yeah,
there's no need, third line, there is no need for me to go over each plan I've just stated. You will always see a UPB site,
Yes.
a 1 kilometre radius, but built-up zones falling within it.
yeah, so that may, well,
That seems to be her evidence, at any rate.
we'll proceed on that basis.
Yes, my lord, I'll just refer your lordships in a few minutes. I do understand that they start at document BW, BX, BY, BZ at pages 2969 onwards. My friend can, for the other areas of Mauritius, as from document W.
Right, well, let's move on.
Right, so my lords, this we were talking about the NDS. So the NDS, there is only one policy as far as I'm concerned, is the policy NR2, and it is permissive, and at the end of the day, their ladyship were wrong to have applied the prescriptive, the rigid approach. The second guideline is the planning policy guidelines, the PPGs. And if I may refer, my lords, to paragraph 102 of the written submissions before the Supreme Court, page 3296.
Mr. Saucier, it would help me if you could say which volume in each case.
Yes, my lord, volume 6. I'm sorry about that.
Volume 6.
Volume 6, page 3296.
I don't think so.
Oh, sorry. I'll just... You've got volume 6, volume 6, I understand.
No, it's not going to be volume 6, page 3296.
It is? Yes.
3296 is in volume 15, I think. Oh, no, 15, yeah. Oh, no, it's 14.
I do apologize, my lords. Yes, your volumes seem to be much thinner than ours.
14.
Not 14.
Is it not all 15?
But we do, I mean, this is a quotation from these documents
Indeed,
in your
indeed.
case, but we,
Indeed.
in your case in the Supreme Court, but we do have the documents themselves, don't we?
Yes.
Because I think we've been given a very helpful little crib sheet. Which I
In
moment.
fact, reference is made, in fact, the PPGs, my lord, the documents, the two documents are documents BF and BH, if I may just summarize. BF and BH, where it is purely indicative and not prescriptive. The same, there is absolutely no inconsistency between the NDS and the PPGs. It is permissive and not prescriptive. Your lordships will see document BH and BF. It is my volume 5, my lords. I don't know whether it is at page
2597.
BF is at page.
2597.
Sorry, Mr. Saucier, we went to 3296. I'm not sure what point you made about the document of 3296.
3296, I was making reference to the written submissions made on behalf of the appellant
Yes.
before the Supreme Court. That is, we were respondents then, co-respondents, in fact.
Yeah, but that's just a reference to them, as I
Reference.
point out.
And
The
your-
documents themselves seem to be likely to be at 2597 or thereabouts.
Exactly, my lord. This is document BF, in fact.
And BF is, bit of it is at 2597 anyway.
Yeah. Yes. And your lordships will see that document, if I may refer to this document
You're going to
BF.
have to bear with me. I'm very
No,
sorry.
it's all right.
That's 10.
10, yes.
This is design
sorry.
guidance.
Design guidance, and if we may, if we look at this document BF, we have a look at paragraph 2.5. First of all, the 2.3 and 2.5. 2.3 is at 2597, and 2.5 is at page 2598.
Yes?
Once more, it says that it should be applied with a measure of flexibility. The word is flexibility, not prescriptive. So the PPG and the document...
Sorry, this is not a PPG, is it? This is,
It is.
design guidance.
This is, yes, this is what we call PPG, Planning Policy Guidelines.
Well, you say that, but I mean,
But I mean, what design are we talking about here? Is this design of individual buildings or design of...
General, my lord.
Does it
General
apply to
approach?
how you design a morcellement?
It would be, my lord, it is a general approach to design, and this is the guidance for every development.
Seems to start on page 2593,
Yes, indeed. This is document BF.
and it's issued by who?
Ministry of Housing.
Yeah.
But it's, the planning policy guidance is dealt with in the national strategy, and this is something quite different, I think.
Well, rather than go round the world for sport, can we have your submission as to the status of this document?
Yes, the status of the document, it is a guideline, and the purport of my making reference to it, it has been produced before the court, is that there is no inconsistency. That is, the courts have said there are three guidelines: NDS, PPG, and then you've got the BROS, the Black River Outline Scheme. If there was any inconsistency in between the documents, then we would have had to apply our minds to the proper approach. But in my submission...
In particular, what is its status in relation to the case that you make, that this policy has to be applied flexibly, or at least that the buffer zone has to be regarded as a flexible, indicative?
Yes, my lord, yes. When we go through these documents, that is the PPGs.
Does this require that anyone approaching the issue of the buffer zone
Yes.
must do so in a flexible manner? I mean,
2.5.
Yes, my lord, 2.5. This is BF, document BF, but when...
Page 2598.
2598.
Below.
Yes, you will see the second paragraph after the three bullet points.
There is actually a paragraph headed Status of the Design
Yes, that's quite
Guidance
helpful.
Yes,
at 2597, paragraph 2.2.
yes,
So it's a national planning instrument
yes.
under the terms of the Planning and Development Act
Act
2004.
In fact, it is,
Applicants should demonstrate that they've taken account of it.
yes, it is section 13.3 of the Planning and Development Act.
And then there are many other controls on development. The Building Act, the Environment Protection Act, the Roads Act,
Yes,
and presumably the Town and Country Planning Act.
yes,
Right.
yes.
Okay.
But does this talk about buffer zones?
In fact, my lords, these guidelines are to be found, I just mentioned it, section 13.3 of the
2624.
Planning Development Act. It is volume 1, tab 2. If we have a look in that chapter,
Oh, I see.
lords, at document BH is at page 2624. It is another guideline.
Yes,
BH 2694.
And
up to 1 kilo.
2624. And once more, my lords, you will see that when we look at this page, that there is an indicative buffer distance between bad neighbor industry and sensitive land use, middle of the page. and went down the page, quarry, stone crushing plant, it is up to 1 kilometer. This is where we say there must be flexibility. It is up to 1 kilometer, not 1 kilometer. This is the case of the appellants. Now, having dealt with these two planning policies, we are left with the third one.
Did the Supreme Court deal with this particular policy?
Indeed, Malone. They dealt with the three. The third one being the Bros. And my submission...
Sorry, where did they deal with it?
They made reference to all. It is the judgment of the Supreme Court is to be found at page 3365.
Yeah, I got the judgment.
They make reference to PPG at line 12 of page 3377, but en passant.
And so, sorry, which page are you now?
Page 3377, but, my lord, at page 3380. They make reference at line 12, where they say that the PPT shall prevail to the extent of any inconsistency of a development plan. This is where we are aiming at. Yes.
But is there if the planning policy guidelines say you should think about imposing buffer zones of up to 1 kilometre, yes, and a particular development plan imposes it at 1 kilometre, is there any inconsistency between the two?
I would say that what we are saying is that this dotted line, this 1 kilometre, is arbitrary in all areas where you've got a crushing plant. This is what we say. It is not a specific prescribed buffer zone. It has been dotted, but there is no precise location of. It should have been different.
You say it's completely ineffective, don't you?
It is indicative. It
means nothing.
But I think Lord Briggs' question resolves to this. If the strategic plan suggests 1 kilometre, but the actual local detailed plan suggests that it should be a minimum of 1 kilometre, then that is what it should be, isn't it?
Yes. If it says up to 1 kilometre.
No, but if it doesn't say that.
Yes.
If it says 1 kilometre.
Yes.
Not up to 1 kilometre. Then that would prevail.
Definitely.
I mean, isn't it the job of those who formulate the local plan, in this case the BROS, yes, the local scheme, I'm sorry, I'm not using the right language.
Yes,
isn't it the job of those who formulate the local scheme to decide where within a zone of 10 yards or 10 metres and 1 kilometre, yes, to put the buffer around a particular stone crushing plant? And if they choose 1 kilometre, that's not inconsistent with having a flexibility where to put it.
This is, if we got the map, yes, but if we go at the writing, if we have a look at the text, there is a difference between the text and the map. And if there is an inconsistency, as my friend rightly pointed out earlier on, the text has to prevail. This would be my submission as far as the Bros is concerned.
I've got that and written it down.
So, my lord...
well, we've been bombarding you with far too many questions, so why don't you proceed, because you only have a limited time.
Yes, I know, I won't be long. So, when we look at the Bros of 2006, because in 2001, my lords, it was 1 kilometre. Then in 2006, it has been changed, and it is now up to 1 kilometre. This is the approach, the modern approach to the whole setup. If we look at the Bros, there are a number of policies, and the most important one is policy SD1. SD1 is in fact document AA, volume 4, at page 2011.
Yeah. It's on volume 8, I think.
2011, volume 8.
2011, page, volume 2.
Volume 8 for us, SD1.
Volume 4. yes, 2011.
Volume 8.
Yeah.
It's D1.
Now, my lord, this in fact concerns a development within a settlement boundary. This is of importance because Beau Songe is in fact in a settlement boundary. And as I just mentioned, my lords, we have to bear in mind that prior to 2006, there was a minimum radius of 1 kilometer. And this is policy 7.2 at page 1715. And it would seem, it has been accepted by one and all, that there is an overlap between the buffer zone and the settlement boundary. This is the peculiar thing about this specific case.
Sorry, what is 1715?
1715, my lord, is policy 7.2.
Yes, but what's the doc? I'm sorry, I'm not making myself clear.
I'm sorry, my lord.
No, what is it? Is it an earlier version of BROS?
Earlier version of the BROS,
Thank
where
you.
it says it has to be a minimum, it is 1 kilometer.
That's the 2001 BROS.
2001, my lord, yes. Now, this overlap, in fact, has been accepted and defined by a number of witnesses. And if I may make reference to volume 2, at page 912, sorry, my lord, your 912, line 18, this is the evidence of Mr. Phul, Phul, and he says, answer, as far as development is concerned, the district council will have to go by the provisions of the operational scheme, which would be the outline planning scheme for Black River District Council area, that is the 2006 scheme. Under the 2006 scheme, there is a policy SD1, which says that all area within the settlement boundary for such area, there should be a presumption in favor of development. And another witness, Mr. Natu, a sworn surveyor, at page 1019, volume 2, 1019.
Yes.
He also has the same view that it has to be a general presumption for development. Now, a settlement boundary, my lord, as it has been said, is defined at page 2565, document BE, as follows. These usually contain the built-up area of settlement and define the area within which there is a presumption in favor of development.
Suitable development.
Now this is
I'm sorry, in favor of suitable development. Sorry.
This is part of the PPG, isn't it? I mean, it
Yes.
looks like it.
No, it's part of the BROS.
Sorry?
It's part of the
It's part of the BROS.
BROS,
Yeah.
yes.
Is it?
It is.
Of the 2006 BROS?
Yes, no,
Yeah.
no.
So,
BE?
BE.
Sure about that.
So my submission, my lord,
but I
is
mean,
that...
suitable is a word that your opponents focus on, because it doesn't
Indeed,
mean, they say you can have things like warehousing or so on, but
They
not
say,
housing.
but suitable at one part of the, in one part of the evidence, one of the witnesses says it includes, of course, residential developments.
I'm awfully sorry, Mr. Secretary. Surely 2565 is design guidance.
Yes.
Well, it says it at the bottom of the page,
Sorry?
for a start.
And this,
Yes, it is included in the outline scheme, my lord.
I'm sorry?
The definition, this is the definition in the glossary of terms.
Yes, but the document that we're looking at is not the BROS
Yes.
outline scheme.
Yes.
It's the design
I'm sorry about that.
guidance,
Yes.
isn't it?
Yes, yes, indeed.
Thank you.
Yes, yes. So, my lord, at the end of the day, what I'm saying is that the court's conclusion that the buffer zone in the planning instruments was a statutory prescription is wrong. Document which is going to be relied by my learned friends, DMM number 13, was only indicative. In fact, if we have the evidence of Miss Koo at page 985, it is volume 2.
Yes.
It's up at 988, I'm sorry, my lord. In line 24, I will come back to the provisions of the outline planning scheme at the end. Let me now refer you to 2006 development management map. Also, this has changed. We no longer call it a strategy or zoning map. We have introduced since 2006 a map which is called development management map. It is a development management map. It is not a prescriptive map. So,
I'm sorry, where are you?
at page 988, my lord, at
988.
line
About 25.
Yes, thank you.
28.
So it's no longer strategy or zoning, man.
It is a permissive.
Yeah.
So therefore, my submission is that this, in our written submissions, I do not propose to go into the written submissions, the written case on behalf of the appellants. At page 3674, that is at paragraph 40, reference is made to a prescribed buffer zone, the Apravasigat, which has been referred to. And, my lords, also, when we look at the written submissions, there is a number of case law. I don't know whether your lordships wish me to go through all the case law. I think it has been...
Well, you could,
I haven't got much
just
time.
over half an hour, so you must take your own course.
Right, so if I may, my lord, the meaning of development plan, which has a legal status and legal effects, it is to be found in the case of Tesco scores against Dundee City Council, my lords. In fact, it is tab 12 in volume 3, and paragraph 19 is the one which is referred to in my written statement.
Do you have an electronic page?
I'm sorry, my lord.
Electronic page?
Yes, my lord. It is at page 3674. I'm sorry, my lord.
3674.
Indeed.
Thank you.
Then there is the interpretation of the planning policies. It is wrong to have a planning policy interpreted in its isolation. That is only one, or all must be taken care of at the same time. That is, there are two, in fact, decisions, my lord. The case of City of Edinburgh Council against the Secretary of State for Scotland, 1997, which is tab 6, volume 3, page 3679. Okay.
I don't think it's 3.
This would be City of...
No,
it
something's
is
gone wrong.
at page 4297.
Hard copy.
Yeah.
And the case of Rochdale Metropolitan Borough, which is at page... Rochdale,
Sorry, which authorities volume are you in?
the case of Rochdale Metropolitan Borough Council.
Which volume of authorities, please?
Volume 3, tab 6.
Lord, it is authorities volume 3,
Yeah.
tab 8, page 4319.
8?
Yes, Rochdale.
Oh, Rochdale you're in now.
Yes,
Sorry.
Rochdale. These are the two cases. So therefore, my lord, this deals with part of my submission. We have to bear in mind that the vocation of the Black River scheme is residential. This is according to the witness called by the respondents today, Mr. Fundan, at page 45 of the brief. And there must be flexibility in applying all these rules, and this has been the stand which has been adopted by most of the witnesses, except even the courts thought that my learned friend appearing for the respondent in their judgment, that my friend said that it had to be flexible. And Mrs. Brown, called by the respondents, also stated on 2 occasions that there is this element of flexibility which has been introduced in 2006. Now, there is one thing, my Lord, that I must go through before coming to the second point, is a policy which has been referred to by all the parties throughout the case, and which I don't think applies in this case, is policy ID 4. Much reliance has been, it is in fact to be found at page 78 to 80 of volume 1. Policy ID 4. No, it seems to be in 78.
Yes.
So, my Lord, this policy has been referred by the court by my learned friends appearing for the respondent, number 1, that it was of importance and it had a direct bearing on the case. My humble submission is that this policy only applies to selection of new sites for bad neighbor developments. So it doesn't apply to our case. And your lordships will see that at page 151 of the brief, in spite of it being referred to on a number of occasions by all parties, in fact, at page 151 of, in fact, it is the reply on the part of the respondent, now, the appellant before the court, C, your lordships will see, C, which is at line 25, the guidance in policy ID 4 of the BROS for bad neighbors, the G3 plant, which is in fact the plant we are talking about, the United Basalt, of the appellant, does not fall in this category. So this is admitted by the respondents, although it is not on a number of instances by the respondent in the written case and whatnot. I think that, to be fair to one and all, even our witness, Mr. Signan, made a wrong inference at page 1100 about this policy. I think that this does not apply, and most of the parties, most of the witnesses were not on tune. So my humble submission is that, therefore, of course, if we were to apply this policy, it would be, once more, the element of flexibility would have to be entertained. So this deals, my lords, with the planning instruments, where in all the policies, whether they apply or not, there is this element of flexibility which has not been considered by the Court of Appeal and which should have been considered. The second point, my lord, the second point before your lordships concerns the paragraphs 30, 31, 32, and 33 of the agreed statement of facts, which concern the facts, in fact, whether their ladyships went through the whole facts of the case instead of applying the law, the application of the law. Now, my submission is that one can only, under section 6.1 of the Environment and Land Use Appeal Tribunal, appeal to the Supreme Court on the ground that the said decision is erroneous on a point of law. And this is to be found in the case of Ashbridge Investments.
Well, it's in the Act.
Indeed, section 6. So it is in the Act, and I think that in my written case, your lordships will see that there are a number of cases, there is no need to go through all these, where...
But I mean, if the Court of Appeal, the Supreme Court took the view that the tribunal had misinterpreted
Yes.
the policy, and if they had, then that was a point of law.
Yes, indeed.
So, I mean, that's what it turns on, so I don't think it's...
Indeed. So it is purely for your lordships to appreciate whether they did inquire de novo on a number of instances or not. So I don't think I will need to go through all the cases. And we should not forget that there have been 26 sittings before the tribunal, and there have been 80 documents, 78 documents, which have been produced.
Yes, I mean, the point that can be made is that the tribunal were a specialist tribunal.
Exactly.
And I mean, to what extent, though, where you've got conflicting, you've got lots of different policies.
Indeed.
And someone's got to sort of put them together and make some sense of them.
Yes.
Isn't that a proper task for the specialist tribunal rather than the
Absolutely.
Supreme
They are
Court?
the
Yeah.
specialists, and they deal with matters like that every day. And in these judgments, in the case of Sudan, it is clearly pointed out that there are experts dealing with a specific issue, and that it would be unwise to disturb unless there is a perverse interpretation or really a wrong interpretation. So, my lords, this is in fact the case for the appellant. Of course, there is another point, if your lordships wish me to address on the issue of legitimate expectation. I do think that a plain reading of what is meant by legitimate expectation would be sufficient for me to submit. It has been referred to by my learned friend appearing for respondent number 2 before the Court of Appeal, Mrs. Lowe. What is a legitimate expectation? It can only arise where a public body has a discretionary power and it will exercise that power in a particular way. Such representation may be expressed in the form of an explicit promise or statement, or they may be implicit in the form, for example, a consistent past practice. There is no such case.
I'm sorry, I missed that. Who's relying on what legitimate expectation?
It has been referred to in the judgment, in both judgments, in fact, in the findings of the tribunal, and also at the end of the judgment, their ladyship's Court of Appeal in Mauritius, they just brushed the issue of legitimate expectation. So in my submission, when there is nothing which was promised, there was nothing, the UBP went changed from Quatre-Bords and Saint-Jean to Geoffroy, the site which is today in issue, and there has been never any promise on the part of any authority that they would be guaranteed whatever buffer zone for ad vitam aeternam. So this.
But it all depends on the outcome of the first argument, doesn't it? Really, and if you're right that the buffer zone was merely indicative.
Yes.
That is incompatible with the notion that there has been a legitimate expectation created. If, on the other hand, the 1 kilometre buffer zone was a firm prescription, then it's open to the respondent to say, well, we had a legitimate expectation that that would not be encroached upon.
Even though, my lord, that if there has been a change in the approach of the authorities, that is in 2001, when we've got this 1 kilometre, and then in 2006, when they say it's up to 1 kilometre, and we've got this settlement boundary which says you can develop. So all this, and there must be a precise and definite zone which has never been done. It is indiscriminate. My friend was going to give me, yes, les maps, the maps your lordships did ask for whether there were in other areas of Mauritius this dotted
yes.
And
yes, well, I did find one at 2969.
Is it B?
One which was the Pamplemousse one.
Yes, in fact, you've got a number from BW. I understand that there have been a number of maps which have been produced. If I may, whilst my friend is on his feet, I will certainly have a look at the maps. And
that has 2 similar zones.
Exactly.
And I think that's
and the evidence shows that within the zone you've had constructions around the place. That would be my submission.
Could I just
29.
ask 2 points of clarification?
Yes, my lord.
Where do we find the ministerial grant of the license, which is under challenge here. I mean, this all started with the minister granting the environmental
EIA
license.
application.
I couldn't find it.
EIA license.
Well, I mean, don't worry now. But if
I will have a look.
Exactly.
The EIA license, in fact, yes, which
Yeah.
is given by the authority, yes.
the other point is on the composition of the tribunal,
Yes.
page 1358,
One,
which is the end of their decision, we see the names.
yes.
Can you just help me on their composition? I mean, the chairperson is a lawyer, I think.
Yes, in
and-
fact, Mrs. Badin
Yes.
is a lawyer. She has been a magistrate.
Yes.
And Mrs. Jiwa is a solicitor. Solicitor.
Yes.
And in fact, the chair, the other lady, in fact, I've got,
Dr. Mohi.
yes, in fact, she is the Dean of Faculty of Engineering at the University of Mauritius.
So she's an engineer.
She's an engineer and environmental engineer.
Right. So
She's the Vice Chancellor of University.
they would be, well, she obviously has special expertise.
Absolutely.
Do the others have expertise in planning?
My Lord, they have been sitting in the tribunal since its inception.
So they will have developed.
Yes, they deal with it, with cases like that.
Anyway, it's a specialist tribunal and includes an environmental engineer.
Indeed. I will give,
Thank you.
if your lordships wish to have a CV of the...
No, I just wanted to get...
She's the Vice Chancellor of University, engineering degree, energy and environment from La
No,
Grande
don't worry,
Bretagne.
just to get what her expertise is, and it's
Yeah, she's an expert in
relevant
the
but
field.
not legal,
Yes.
right?
Thank you, my
I
lords.
think you were going to tell us, Mr. Sezier, where the Bross outline scheme dealt with buffer zoning in the text. There's no need to take us to it, but could you give us the page reference, please?
SD1. Policy SD1?
Because you made the point that there was a difference between the map and the text.
Indeed. My friend did, and I...
Oh, it's SD1, is it? That's what,
SD1.
That's it?
Yes.
Right, thank you.
Thank you, my lord.
Thank you very much indeed. Mr. Patton, would you like to follow?
Something on the EMM. In 2011, the development management map was amended, and the other village of Bamboo, the town planning board extended the limits of settlement boundaries to allow residential development within it. And perhaps your lordship will at page 1642, which is part of the report.
Did you say 1642?
Which is part of the report of Mr. Fundan, who deposed on behalf of today the respondent.
This is a map.
Yes.
And your lordship will find a little kink at the end of Bamboo.
Yes.
And so it has been added, if you compare it with the document N, this has been added by the town planning board, and I humbly submit that the inference to be drawn from that is that the town planning board allowed an extension of the settlement boundary to include what's for the VRS, which is for the voluntary retired sugarcane workers, voluntary retirement scheme. And notwithstanding that, they did not amend the 1 kilometer circle. So even in 2011, the intention of the board was simply to increase the settlement boundaries, to include further residential development, and they did not touch the 1 kilometer circle. And my inference is that this is for the town planning board indicative as opposed to being fixed prescribed.
The spike on 1642 comes within a kilometre, does it, of the diamond? Must do. Have we got the circle on that map?
No, but it's way inside,
We may not, but
It must be well inside.
so it's right, it comes right out.
Sorry, I haven't quite caught up with this. The area you're referring to, the change,
Yeah.
comes where?
it is not.
But it's entitled VRS MORC
32A65. Yeah, I see. So that's a change from the
It's a
previous.
change.
Yeah.
Well, to bring the settlement boundary closer to the UBP plant, yeah, you can see, the diamond symbol.
Your point is that that was treated obviously as indicative rather than prescriptive.
Yes, because otherwise they would have amended the 1 kilometre to exclude that bit which they've got into the 1 kilometre.
Well, the map that's being relied on has quite a lot of bamboo within the circle, doesn't it?
Yes.
Yeah.
Yeah, it does. It does.
That was
Now, are they actual houses, or is it simply a settlement boundary?
It's houses.
Built houses?
Built houses, and it continues growing. I mean, local authorities are not refraining from issuing building and use permits for residential development within that zone.
Yes. Very much.
If I may just answer to your lordship, the EIA license is to be found at page 2977A.
2977A.
A.
Thank you very much.
Thank you, my lords.
Mr. Guthrie, are you going to keep your powder dry until the end, or are you going to...
I'd like to keep it dry.
Right, okay. Mr. Beau.
First of all, my lords, in answer to the question of where does it say that the minister is the person who gives the license, your lordships may wish to look at the Environment Protection Act, which is at MS page 3798 of what is called Authorities Volume 1. If one goes to section 23 of that act,
Sorry, section?
section 23, my lord, of that act, your lordships will see entitled Decision on EIA, Decision on EIA, subjects to subsection 3 and 4, the minister shall, after taking in consideration recommendations of the EIA committee, make his decision as regards the giving of the EIA. And of course, section 24 follows, and this is entitled EIA approval. And in considering the approval of an EIA, account shall be taken. Your lordships might see there policy, environmental guidance, etc., etc. So that's the first point, which I believe your lordship asked.
Well, I know where, I was trying to find the actual document.
Okay. And the document is what Malenfen has indicated to you.
I'm
The
afraid I
EIA
haven't
license.
found it yet.
Oh, you haven't found it yet?
No.
Well, can I just indicate to your lordship, therefore, that the EIA license itself is to be found at page
2977.
2977.
Yep.
2977A.
2977A.
2977, the EIA license.
A to D.
Which I...
Yes.
Sorry, Japan, my 2977.
It's A, 2977.
Next one.
A.
A? I haven't got a 2977.
I haven't in the bundle, but it's on the screen.
Oh, I see.
Yes.
A.
Yeah.
It was added.
2977 little a.
But I don't have the document. That's the trouble.
It's on the memory stick.
2977.
It's not.
Yeah, no, I've been trying to find the document in the bundle.
Just scroll down from 2977.
I see, it's
Right,
977.
Mr. Beau.
Yes, ma'am.
carefully hidden.
Then,
Can I find this? I read it,
yes,
it's not
madam.
too much to ask to see the document, which is
Yes,
under challenge. Right, I've got it now.
Absolutely,
Thank
my
you very
lord.
much. But it isn't in the documents, and I've got it on the screen. Can I just have a look at it? Right, thank you very much.
Yes, my lord. So that is where the EI license is found in the bundle. Then the third point, I believe, Your Lordship asked, concerned the the use of the word outline scheme. Now, if one looks at the Planning Development Act and section 15 and 16 in particular, and this is at page number 3896.
Sorry, say it again.
3896. That is in the Bundle Authorities Volume 1. And section 16, which is at page 3898. I believe your Lordship, Commonwealth, asked about the old use of the word outline scheme,
yes,
and the fact that now, under this law, it is to be called development plan.
But that's a different thing.
That may perhaps be the different thing under this section of this law, but there is a transitional section, and this transitional section is to be found in this PDA, and can I take your Lordships, therefore, to page 3949? Page 3949, we are in the same Act, and 3950, and the section 75 of in that law,
yes,
as a saving and transitional provisions.
But that preserves,
yes,
75.4,
yes,
scheme enforced immediately before the commencement of this Act.
Absolutely.
Well, the 2006 scheme was
yes,
not enforced before this Act.
It says the outline and detailed scheme approved and adopted under the TCPA, the Town and Country Planning Act, and enforced immediately before the commencement of this Act,
yes,
shall be taken to be a development map approved under Section 15 of this Act.
Yes, but the 2006 plan, which we've been talking about,
yes,
was not enforced immediately before the commencement of this Act.
The 2006 scheme, which is the Black River Outline
yes,
scheme, is the one of 2006.
Yes, but it wasn't preserved by Section 75 because it wasn't enforced then. I mean, this is the 2004 Act, which was brought in to effect at various stages. I mean, it may not matter if everyone's agreed that the scheme is what we're talking about.
It does, my lord, but I'm just...
It's a mystery to me to see quite why you've got this splendid new scheme with lots of development plans, and you still seem to be sticking to the old outline schemes under the 54 Act. But
we speak of the Black River Outline scheme.
Yes, but everyone seems to accept that's the relevant
But this
one.
is common ground, yes.
Yeah, thank you.
Yeah. So those were the three questions which I thought I would answer.
Thank you very much.
Now, the case of the respondent number one, as your Lordships has seen, and is the nature and legal implication of the 1 kilometer buffer. And this 1 kilometer buffer is provided for in the Black River Outline Scheme of 2006. Your Lordships asked, and we've now identified that this map, which we call Development Management Map, one of three, is the one which is in issue today before your Lordships. It is the same which was in issue before the Tribunal and before the Supreme Court. the first respondent has always said that in its appeal before the tribunal and before the Supreme Court and today before the board, that it considered that there had been a breach of the law, an infringement of a right given under Section 14(3) of the Town Country Planning Act. Now, this section, which is 14(3), Your Lordship will see in the Act, and it is in page 4016, still in this Volume 1 Authorities, and Your Lordship will see Section 14 entitled Approval of an Outline Scheme. Now, of course, we know now, my learned friend having referred to that this scheme is provided for in the Act, Section 11, which calls for its preparation, Section 12, which is the procedure of depositing that scheme. Then there is Section 13, which refers to the submission of that scheme. And finally, the approval of that scheme, which by subsection 1 stipulates that the President may, with or without modifications, approve any outline scheme submitted to him under the Section 13, subsection 2. What is material, of course, in this matter, and before the board today, is 14 subsection 3, which reads that as soon as a notice has been published, and it is common ground that the notice of the scheme has been published, as soon as that notice has been published under subsection 2, the scheme shall have full effect, and no authority shall pass or approve any plans for building or development that contravene the scheme. So that if it is accepted that there is a scheme, if it is accepted that this scheme had followed the procedures to approve it as an outline scheme, then the scheme containing a map, and on that map there being indicated a zone, which the respondent number 1 says it is a zone, and it has marked on that dotted line around the central point, which is a diamond shape, there is marked 1 kilometer buffer. So this section, therefore, establish that nobody can contravene the scheme. And can I just stop there to indicate to Your Lordship, when one looks at that, one doesn't really need to see whether the tribunal was an expert tribunal in the sense of having knowledge and experience in schemes. One doesn't need also, in my submission, to have the services of the witnesses who came to depone. There was Mrs. Brown, who was the person who had participated in the whole project of the National Development Strategy. There was Mrs. Koo, who also participated in the creation of that scheme. But if there is a scheme, and if Section 14(3) establishes that one cannot contravene the scheme, then our submission is that is perhaps the end of the matter.
Well, I mean, the problem is whether you interpret the circle as being definitive or indicative.
Of course.
And unfortunately, there's nothing in the document itself which tells you the answer to that.
if one looks at the map, and that map contains a legend, and the map is to be seen at I believe 1581, MS 1581. That's a large map which I see your Lordship has. A copy is not the best one which would be possible. We have a copy which is more precise and and so. But what I wanted to draw your attention of your Lordship is that this map has a key policy number. Now, looking at the map.
Sorry, where? Yes, the legend has a key policy number.
Yes, the legend. Yes, yes. This is where, on the third column of that legend, one see key policy number. But before going to that.
Sorry, I'm being very slow about this, Mr. Reba. I'm sure it's my fault, but I don't think, if we're looking at 1581, I don't have a legend.
For some reason, it doesn't have the legend on it.
Well,
but the electronic one does.
I have a more sort of explicit copy of that. May I be allowed to just hand it over to your Lordships?
I should say the electronic doesn't have the dotted line.
Oh, it doesn't. This I've seen myself. Can I?
Yes, 1581.
Also your indulgence and place one like that before each of your Lordships, so that it will be easier perhaps to follow rather than the electronic version.
There's the dotted line.
No, I have copies for all your Lordships. Oh, unless
Are we looking on the legend for something about a buffer zone?
well, we are looking for.
Oh, are we?
We are looking.
Where? I can't see it on the legend. Yeah, I can't. Where is it on the legend?
Well, on the legend, it's the last line, my lords.
Oh, I see. Stone
Yes,
buffer.
it starts with a diamond, and then we have the phrase stone crushing plant, stroke buffer zone.
ID4.
Yeah, and this is where we have this key policy number ID4. Your Lordship may well.
But can we just get the plan out? Because this is quite important.
Yes.
The first time
I have a copy for you.
I see.
My Lord Carnwath.
ID4, for some reason, that was cut off on page 1581.
Do you say ID4 is the right reference?
Well,
because on the face of it, ID4 is about new plants, isn't it? Anyway, whatever it's.
This is what.
That's what it actually says. Anyway.
This is what it actually says. So we have therefore this legend. And the key policy number is indicated to by ID4. No doubt that may explain why most of the persons who deposed in court, and ourselves in fact, we referred to the first referent policies as being ID4.
So this is a new point, which is quite significant. You're saying the stone crushing plant is your stone crushing plant.
And the stone crushing plant with the diamond is the stone crushing plant of the respondent number 1.
Particularly related to ID4.
And for some reason, the Black River Outline Scheme and the board who published that scheme with the map placed on it the reference ID4.
Yes, but I mean, we are told that the words of the policy override the plan. Is that,
I've got one.
Yeah.
He's got one. We've all,
Yes.
We've all got it.
So, can we read in the ID4 policy, which is a BROS policy, which is the policy within the Black River Outline Scheme, as one sees it at page 2036. 2037 and 2038 of the written part, as my Lord Beau suggested earlier on, and the written part referred to in the map is ID4 Bad Neighbor Development.
Yeah.
Now, the title Bad Neighbor Development would suggest that it deals with bad neighbor development, whether new, present, or old. The starting sentence of that BROS says the location of bad neighbor uses should follow the approach commencing with policy SD3, and where buffer zones are required, or potential nuisance exists, again, one may surmise and say, why should it not apply to present crushing plant? But even then, we policy SD4.
Because it wouldn't be development.
Yes, quite simple. So bad neighbor developments are defined to include, we know already what is bad neighbor development, and then we go to the second page, and on that second page, we see that acceptable uses, this is the, after the bullet points, my lords, one would read acceptable uses within buffer zones may include other activities. This, of course, is an answer to what my learned friend for the appellant suggested, that, if you create a buffer zone there, it creates some kind of desert, a blight, where nothing can happen, which is not quite true. When one looks at the definition within a buffer zone, one would see in ID4 that acceptable uses within buffer zones may include the development that your lordship sees is contained. There's even other uses which is possible within the buffer zone, which is storage, warehousing, distribution industries may also be appropriate at varying distances from a bad neighbor cluster. Now, again, one may stop there and say, why is that not applicable to present or old operating crushing plants? Then when we go to justification, then again, we are in a bit of a confusion, if I may colloquially say so, because it says this policy, ID4, recognizes that bad neighbor uses are essential for continued economic growth of the Mauritian economy, but that a precautionary approach to citing new facilities, well, there we are again, my lords, which of course prompted my little friend to say, well, that is not applicable at all, since it cites new facilities is required to safeguard the local environment and amenity. And then there's a definition of what bad neighbor developments and when we turn to page 2038, again, the last but one paragraph before the topic agriculture, this is 2038, of the same document, BROS document, that again, one sees in selecting new sites for bad neighbor developments, locations for some particular activities, such as, etc., etc. Again, suggesting that one may perhaps use that exclusively for new sites. I submit that this, appearing as it is in a justification of the creation of buffer zone, appearing as it is, and is not exclusively meant for new sites. But this is as far as I can go, my lords.
I mean, if this is the relevant plan,
yeah,
it doesn't really support your proposition that it's got to be 1 kilometre. It says up to 1 kilometre. That sort of supports the view that the circle is actually indicative and not definitive.
The map doesn't say up to 1 kilometre.
No, it gives a circle, and we're trying to find out whether
and
that's
on that circle,
or definitive.
And on that circle is
if
the
one's
word
relating it to
1 kilometre buffer.
One assumes that it's referring to something which is up to 1 kilometre.
Well, this is where respondent number one has been saying that one has to make a distinction. One has to operate a distinction between the policy, which recommends that you must have a buffer zone, but depending on where you are, in the region of the island of Mauritius, you may wish to put a buffer zone which is anything up to 1 kilometer. This is so that the wording up to 1 kilometer appearing as it does in the general policy doesn't preclude, of course, any council of the regions of Mauritius to be deciding that in our particular case, for this particular crushing plant or bad neighbor development, we shall decide that it should be 1 kilometer. So, in fact, this is the whole issue which is before your Lordship.
So your point is that ID4 permits the creation of a buffer zone up to 1 kilometer.
Yes, absolutely.
But when the local council decides that it should be 1 kilometer, that becomes a prescriptive.
That is my submission to your Lordship. And may I add on that of course, it must originate from the local council. Let us just say Black River Council for the purposes of our case. But the suggestions have to go to a board, which is the board created by the Town and Country Planning Board. And on that board sits not only the representative of the Black River Council, the planning council authority, but also other members of the ministries.
Right. But your submission develops along the lines that once the 1 kilometer buffer zone has been established by the council or the local authority, whatever, you can't revert to the general policy to say that the 1 kilometer buffer zone fixed by the council continues to be flexible.
Yes, you can't do that. This is our submission today, and has been our submission before the.
Okay.
Now, we say this also for one reason, which is that this scheme, once it has been published with what it has, maps, etc., is not as if a static one which you can never modify or move. Section 24 of the Act, the Town and Country Planning Act, Section 24, and this is page 4021, specifically provides that the board may apply to the President for the revocation or modification of a scheme, which has been approved under Section 14. When one reads that, means two things in our submission. Means, well, once there is a scheme, it's got to be adhered to, the map included. But if this scheme needs any modification, then Section 24 provides for it. But this modification is not a question of depending on the applicant of the EIA. This modification has to follow the requirements of Section 24. This is what we say. We say that because in our submission we shouldn't be taxed to be saying that this buffer zone cannot be moved at all.
No, I understand that. But going back to the point was being put to a moment ago, policy ID4 is the written policy, And the plan was produced at the same time, wasn't it?
Yes.
So it's not a question of ID4 coming out and saying we need to have something up to 1 kilometre, and then the board saying, well, we'll decide in this case it's going to be actually 1 kilometre. If anything, the fact that they were produced at the same time suggests it's indicative, and that actually rather supports the planning tribunal's view that it was something which wasn't definitively fixed at that time.
What we submit on that point is the word indicative remains until the scheme has, to use another word, crystallized what exactly would be the distance. And this is exactly what the scheme does. And as long as...
When you say the scheme does, you mean the map does?
The map, yes. When I say the scheme, I use the term scheme because the map is part of the scheme.
Yeah.
The map, but our submission of the matter is as soon as this distance is crystallized in the map, notwithstanding the fact that 1 kilometer buffer may perhaps be interpreted differently, but if 1 kilometer buffer means a zone of the radius of 1 kilometer, then this is what I submit is the crystallization of that distance. Of course, if the zone had been placed by the board of TCPA at 2 kilometers, that would be inconsistent.
But wouldn't you expect to find some evidence that someone had actually, given it's got to be up to 1 kilometres,
yep.
That means someone going on the site and saying, well, in this case, because of the following reasons, we decide it will be 1 kilometre.
Yes, yes.
And there's no actual indication that happened, is there?
Well, the indication is in the publishing of the outline scheme.
Well, that's the only thing you can play, but there's no evidence, as I understand it, that anyone made a considered decision that in this case it was to be 1 kilometre rather than something less.
Well, my assumption, one may infer that if it is so placed in the scheme.
So do you say that the board, or whichever body or agency is the progenitor of the scheme, must elect to fix the buffer zone? In other words, if you're preparing a scheme, you've got to choose as 1/2 kilometre, 3/4 a kilometre,
yes.
or 1 kilometre. You've got to do that.
You have to do that.
Yeah.
As you have to do that as long as you don't go beyond.
You can't go beyond the 1 kilometre, but you could equally provide.
It could have been 800 meters. Could have been 7 meters, 700 meters. I'm so sorry.
I think my Lord's difficulty in understanding relates to his view that it might be possible for the board preparing the scheme to say up to 1 kilometre.
Well, that's what the other side is saying. I mean, I'm just trying to put to the other side point, indeed the tribunal's point of view.
I understand Lord Gornwoff's
you want to show the tribunal's thinking was
question
of law.
Yes, I do. But when one comes to see, to think about it, one sees the policies. It is my submission that a scheme which would say, there is a crushing plant there, with all the effects that a crushing plant may cause to the public in general, whether perceived or not perceived, will put it as being anything between 0 meters and 1 kilometer. I submit that the policies, when one looks at the policy, and I'm shortly going to come to the policies and indicate to your Lordship, by reading the policies, one see that the philosophy of the whole matter stems from the National Development Strategy, and that this development strategy, amongst many things, puts forward 2 main features. One, that yes, there is a certain amount of flexibility, but that flexibility comes to an end when the scheme is voted, but does not come to a definite end since Section 24 may use to modify. This is the first feature. And the second feature is that the National Development Strategy also indicates in its numerous philosophy that in its numerous principle that it is better that some features should be clearly established and not left to the, I was going to say whim, but that's very unfair, but not left to the discretion of various planning board and authorities, which means that you would have a situation where depending on the application, then some applications would be allowed, some would not be allowed. I submit, but that's of course not the proper forum for that. I submit if one were to ask oneself the question, what is the policy, what is the aim behind the National Development Strategy? I submit that the answer would be, the aim is to, in the case of bad neighbor development, to protect the health and safety of residential clusters, and at the same time to establish a rule which would indicate to any potential investor, any potential buyer of any land, to go there and look and see, there we have a zone. And of course, in a zone, see what can or cannot be developed. Now, can I, before I mention those policies, which we submit is relevant to the establishment of a buffer zone and the 1 kilometer, just remind your Lordship to one of your questions which you asked, which is the establishment of the board. Lordship asked this is of course contained in the Town and Country Planning Act of 1954, and this is at page 4009, still in the volume 1 authorities. Your Lordship will see there the composition of the board. But, if I may add, in our case, I'm looking for the date, this board was I'm so sorry. Did I indicate to your Lordship the section 3? I'm looking for the tribunal, not the board. The tribunal, the composition of the tribunal. You'll already ask it on the composition of the tribunal.
This under the Act,
yeah. This is in the Land and Environment and Land and Use Appeal Tribunal. Your Lordship,
page 3961.
That already. Yes, this is 3961.
Yes.
And the establishment of the tribunal, your Lordship will see in 3962. And your Lordship knows that the chairperson was a barrister.
Yeah.
One assessor was a solicitor. The chairperson, the barrister, at the time was a magistrate. Magistrate listening to cases which the district courts usually listen to, which of course has nothing to do with environment features or cases. The second one, the assessor, was a solicitor, what we call an attorney in Mauritius, and this attorney is, of course, practices privately. And
well, in a way, this is entirely incidental to your main argument, isn't it? May I just ask, if Beau Songe wanted to have the scheme modified, would it be open to it to apply to the board?
Yes.
So that the board would then apply
absolutely.
to the
Section
president?
24.
So that's the way that it should have proceeded in.
That is the way it should proceed. That is the way it should proceed. There's a question which I asked when I was before the tribunal, and Mr. Colli, the representative of Songe Development, the appellant, said that I knew that the previous EIA license given to Medzin, the seller, had lapsed, but I did not know that there was a buffer zone. The answer to that, I don't want to go more than that, the answer to that is if one looks at the scheme and the management map, then one immediately sees that.
How did the original EIA come to be granted?
Now, the EIA originally was granted to Medzin before the 2006 BROS, as I call it.
Oh, I see.
Yeah, but still,
worry about a buffer zone.
and at the time, there was before 2006 there was no buffer zone.
Well, there was a policy.
There was a policy, but not the buffer zone.
Well, I mean,
in the map.
Because you were shown at page 1715 the policy as it then was,
yes,
which applied to new stone crushing plants, as indeed ID4 appears to do. And then there was a clear figure of 1 kilometre.
Minimum.
Yes.
Minimum. And what seems to have changed is to make it, as the other side say, more flexible and say up to 1 kilometre.
The chronology on that matter was that the EIA license was extended. I think it lapsed in 2000 no, not in 2009. It lapsed in 2009, but when it was extended at the time that there was a 2006.
Yes, I mean, if we come back to the same old question, what does that circle mean?
Could you go back to the map?
Yes, well, yeah.
If you could possibly look at the one with the legend on it, it would help.
Yep.
1581 with the legend. I don't think Monsieur Sauzier's got one.
Yeah.
Can he have one?
Mr. Souzier,
do you have
no,
one?
No, you'll need it.
No, I can follow it on the. No. I can follow it on the.
No,
Mr. Souzier's got one.
No, I have one.
I haven't got the legend.
Yeah.
Sorry, you haven't got the legend.
Well, you might need.
I can give a copy to him.
Because the question which matters is as it were, the effect of or the status of the dotted line round your stone crushing plant, which is at the bottom of the plan, underneath Bamboos and left of Basalt.
Absolutely, yes.
Right, now then, look at the legend. There are a number of other buffer zones referred to.
Yep.
About 10 lines up from the bottom, there's an indication of borehole.
Yep. There's three buffer zones, in fact.
Hang on, let me just do it this way. There are several boreholes which are blue dots with a circle around them.
Yep.
And if we look at the map, it look to be 1, 2, 3, 4, 5, 6, 7 of those.
Absolutely.
Right?
Yeah.
Then there is sewerage treatment plant and buffer zone. The reference to policy ST2. And we find that up at the top of the map.
We do, yes.
Where it says Mount Jacot. Mont Jacot. And that sewage plant seems to have 2 buffer zones around.
2 buffer zones, yes.
One at 200 metres and the other at 400 metres.
Absolutely, my lord.
What do you say is the significance of those lines?
Well, the sewage treatment plant, and your lordships will see that on the 1, 2, 3, 4, 5, 6, 7 line up from the end. And the key policy number for that is indicated as being ST2.
Yes.
So we should therefore go to ST2 to be able to establish the...
somewhere around 2005, probably.
That's right, my lord.
ST2 is...
I've got it.
2070.
Is that ST2? I've got it at 1947 as ST2, sites for sewage treatment works, but that I think is in
The old one.
that's document Z, which is part
Yep.
of the
2070, I think, is the
207.
ST2 in the current.
2070.
Yeah.
070.
Yeah.
Yeah.
And it says they should conform with policy ID4. Takes us back.
I just wondered whether there was any particular significance in the fact that it had got two lines,
Yes,
and whether one meant one thing and another meant another.
it does indeed, my lord.
Gosh. What's the-
Doesn't look as if
The document is marked document Z.
Yeah, well, ST2 doesn't explain the two lines. Anyway, the other thing to see from this map is that yours isn't the only stone crushing plant on it, is it?
Yep,
There's another one at Bellevue,
there's one in Bellevue.
due north of you,
Indeed, my lord.
and near to the coast, presumably, yes.
Yeah.
And that also has a 1 kilometre buffer
It does indeed,
line
yeah.
around it, just
Yeah.
like yours.
Yeah, it has 1 kilometer buffer zone.
Yes, I see.
Okay.
If it doesn't mean that what section 14.3 says, and that no one can build houses inside it, what does it mean?
Well, it means that one may must follow what is the acceptable use within the buffer zone, and we've seen.
Oh, yes,
Yes.
okay, for agriculture and so on.
You can, or you can have storage, or you can have other what is called light industries.
Yes, fair enough.
So this is what you can have in.
Yep, light industry.
Can you just help me with the meaning of the hatching at Bambus, which comes well within the top part of the 1 kilometre radius from your sewage treatment work? The vertical blue hatching seems to be, if I interpret it correctly,
Yep.
scenic landscape area? Is that right?
Yes, my lord.
So Bambus there isn't a built-up area with lots of houses in it?
No. But of course, when the dotted lines was placed, and when it was placed in 2006 on the outskirts of that dotted lines, certainly there was already there residential construction.
The orange dots
Yeah.
connected by a line
Yeah.
are growth zone,
Exactly, sir.
meaning what?
Meaning that the
SD.
development could at that time be made, except
So can you build houses there?
except that now with the dotted line circle, no more residential development can be effected. If one is to read the meaning of the buffer zone circle.
I haven't looked at SD6 and CDT1, but is growth zone, it's not exclusively residential?
No, it's not exclusively.
No.
And then one has also the orange ill-shaped rectangle with the Songe, but that's the settlement boundaries. That's at the bottom of the map, and this is where the Songe development is placed.
Yes.
Yes, madam. So I was going to indicate to your lordships the 4 policies which mention the policy of the 1 kilometer. The first one is the called the housing directives, and it's to be found in 1816, of the documents, 1816.
Housing policy.
Yes.
And that's the famous fifth bullet point of housing. But this speaks of if I read that to your Lordship, as a sensitive land use, new housing, that is the fifth bullet point under the housing chapter.
Yeah. I think we've read this already.
Well, you've read this.
Yeah.
And of course, you have the parenthesis within 1 kilometer of. Then you have the second mention of the 1 kilometer, that is ST3, and that is at 1947, ST3, 1947. But this, when we read it, is in reference to new sites, ST3, 1947, my lord.
That's new, is that
Yes, yes.
new bad neighbourhood?
Yes, yes, new.
Yeah.
So in consideration, the location of new bad neighbor developments, again, this new reference, including zones up to 1 kilometer from sensitive land uses, should be identified in conjunction with the Ministry of Environment and shown in revised local plans. And then, of course, acceptable uses within those identified buffer zones can include, as usual, agricultural, forestry, etc. Then the third policy is to be found at NR2, and this is 1881, page 1881, I mean. This policy NR, did I say 2, my lord? Yes, NR2. Buffer zones around rock quarries and crushing plants. Reading of that, in my submission, is not exclusively new. It says the policy is to identify buffer zones around existing proposed rock quarries and crushing plants up to 1 kilometer, within which the location of new sensitive land use development will be discouraged in accordance with the policy ST3.
But the justification says at least 1 kilometre.
And the justification says, that's the first paragraph, that the distance from the boundaries of a quarry site shall be at least 1 kilometre from the limits of permitted development or the nearest residential.
So, I mean, how can that be a justification for a policy which says up to 1 kilometre?
Indeed, my lord. and when one looks at the second paragraph, then it states, this should also apply to a new crushing plants in the interest of both the plant operators and those proposing development in the vicinity of the crusher.
But I mean, this is the most direct policy in the sense that it does apply clearly to existing plants.
It does indeed.
So this is where you would expect to find what applies to you.
Because the paragraph saying this should also apply to new crushing plants indicate that it also, of course, applies to present or old, if you want, crushing plants, already existing crushing plants.
But when it refers to the extent being determined in revised local plans and action area plans, that's rather confusing because that's local plans and action area plans under the 2004 Act, which don't seem, whereas you're being in a scheme.
2006, no,
But we don't have a local plan.
In 2004, we may, but we don't have a local map, as we call it.
Right.
Then we have the fourth allusion, which is sorry. The fourth one is ST3. SD3.
Had SD3.
Yes.
We've had SD3 before, haven't we?
Yeah, 1947.
Yeah. I suggest it's I7, 1847. I7. This is the fourth one. And policy I7, this is at page 1847. And this also applies to new and old. And this is justification for that. Bad neighbor industry still exists adjacent to residential or commercial areas, and priority should continue to be given to cleaning up or relocating such industry if there are opportunities of redevelopment. The second paragraph, in identifying new sites for bad neighbor industrial developments, consideration should be given to the clustering of uses on a single well-assessed site and the establishment of a buffer up to 1 kilometer. Again, it's the same argument would apply there. 1 kilometer distant from sensitive land uses, such as reference should also be made to the policy ST3 for buffer zones. So that is, those are the four. Well, one is not a policy. One is the housing, and the three others, ST3, NR2, and I7, constitute what we submit is policies indicating that there should be buffer zone, but the buffer zone is up to 1 kilometer buffer zone.
Yes.
Yeah. So this may conclude the part about buffer zones, maps. The second point is the part of what prevails on what. We've seen the law, what it says, and the intention of the respondent number one is that there is no inconsistency in as far as the general suggests that you may have buffer zone of up to 1 kilometer, but that doesn't mean that when the scheme designates the buffer zone to be of 1 kilometer, that there is any inconsistency in that. So that's as far as the...
In other words, it's indicative at the point of policy, but prescriptive when it comes to the actual making of the scheme.
Yes, that is what it, I submit, comes down to, and
yes.
As soon as he says that, my submission is this seems to be the main issue in this case.
Yes.
I've dealt with the flexibility point. The other points which I deal with in statement of case starts at paragraph 37 and constitute a reply to the grounds of appeal. Ground one, I submit, has already been treated by your lordships. Well, I mean, I've already been put in issue. The ground one suggests that this is entirely a question of fact. We submit not. We submit that it's a question of application of the law, section 14.3 in particular.
Is there, I mean, there's a point related to the Tesco case about interpretation.
Yes.
And what Lord Reid was saying there, that the interpretation of a published policy is, to some extent, a question of law. I wonder, in a more recent case, we did rather call Cheshire, Suffolk, I think, we did rather qualify that.
Yes.
This is volume 3,
yes,
7.
Yeah.
And we sort of said that not all policies are the same, and some, it's really more of a question of judgment on which one should respect the expert tribunal.
Absolutely.
I mean, could that not apply here? That way we've got, we spent an awful lot of time trying to work out what these policies mean.
Yes.
So they're not particularly clear.
Yeah.
And at some point, isn't it a matter for the expert tribunal's judgment to say what the is to be?
That would be the case if there were two conditions to what my Lord Garnhoff is suggesting. The first one is that there is section 14.3, which says, in some way, whatever the policies may say, which seem to be sometimes confusing as relating to new sites or old sites, section 14.3 says, once you have a scheme, you have to, well, not you have, it cannot be contravened.
Can I just put to you the words? It's in the Suffolk Coastal District Council case, volume 3, tab 11, at page 4387. Paragraph 25. Have you got that? Are you with me there?
Yes, my Lord.
And what we said there was, we must remember these policies, statements of policy, not statutory text, and disputes over interpretation may well not be determinative, and the court should respect the expertise of specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. So one's saying there are some policies where really one's got to trust the specialist judge, in our case.
What we submit on that matter is that in our case, nobody, well, I mean, no party is suggesting that it is a change of policy. The appellant...
They did. They said it was a more flexible approach embodied in the national strategy.
Yes, my Lord. There is...
Explain why you move away from a rigid 1 kilometre in the 2001 BR.
Yes.
Which just says up to 1 kilometre.
In my respectful submission, this is not a change of policy. This is an interpretation of what may be general and what may be particular. It's not a change of policy. The appellant, I didn't understand the appellant to be saying that, oh, the respondent is changing completely the policy. That's for the appellant. Now, respondent number 1 itself is saying, we are not asking to change a policy. We are simply asking, in my submission, to apply the scheme. And the only thing that can render the scheme not applicable would be if it's inconsistent with the whole purposes and strategy of the national development strategy. That is what we're submitting. So second point. And the third point is that if Songe felt dissatisfied with that interpretation of the 1 kilometre in the scheme, then Songe had to apply under Section 24 and convince the board to modify it. So that is why we are submitting that the case which Lord Garnhoff you have suggested is not applicable in our case. In this case, it was the one party attempting to change a policy. We are submitting that we're not changing a policy. On the contrary, we are applying it, which is the case. So that the case we say is not, we submit is not applicable in this matter.
Yes.
Yeah. Well, I was referring to ground 1 on the facts, and I was submitting that ground 1 cannot be sustained since the Supreme Court, by treating the policies in the National Development Strategy, the sections of the law were in fact dealing with the law, and not with the fact. The section 2 is the Supreme Court in its judgment considered that the tribunal came the wrong decisions in its application of the following acts and instruments. The same idea, my lord. We are there on question of application of an act, and therefore nothing to do with the facts. As regards ground 3, I've already dealt with that by saying that the question of prevailing doesn't arise because the scheme is not inconsistent with the principles of the National Development Strategy. That's ground 3. Ground 4, there was a point taken about the exact interpretation of the word prescribed. Now, the Lordship will see that the judgment uses the word prescribed in the sense that it uses it. 1371 and 1382, and not 3371, 3382, and 3388, they use the word prescribed in a sentence that this was prescribed. First of all, not in the legal sense of prescribed under the Interpretation and General Clauses Act. But then again, a scheme with its map, which has been created under a section of the law, in my submission, with Section 14 and Section 28, your Lordship will see that Section 28 also makes it a contravention of a scheme an offence, so makes it, in my submission, eminently a question of it has been prescribed for all intents and purposes. That's ground 4, my Lord. Ground 5, it's making a case against the Supreme Court that they did not take into consideration the law. We've alluded to that in paragraph 41, A, B, and C, and I need not go through that again. Ground 6 is a question of factual wind blowing from one side, from one direction or the other. Yes, of course, the facts, but we are not appealing on facts. The appellant is making it a question of fact. The factual matter is at that place for 1 year. The wind blows in one direction for 8 months, and as we are in Mauritius, it's the southeasterly winds. They blow for the best part of 8 months of the year, and the evidence reveals that for 1 or 2 months the wind blows in the other direction, which means that they blow in the direction coming from the UBP stone crushing plant to, therefore, the proposed development. But that is not a point which the respondent...
In case this isn't an issue at all, is it?
It's not. It's not. But, I'm just mentioning that
because
yes, round 6 mentions that. And then there's ground 7 that, but we've already said that when entertaining an application for residential development, the submission of the first respondent is that the authorities themselves cannot reduce a buffer zone already designated by the instruments and approved under Section 14. Of course, with the proviso, is it to be taken as a zone of 1 kilometer radius or not? So that's ground 7. And ground 8, I think, relates to the precise establishment of the center of the 1 kilometer buffer zone. My submission is that is not a point which would influence that matter, because by all standard, the plans of Mr. Funden at 1635 and 1668, the plan of Mr. Natu at 2631, and the plan of Mr. Dutmont at 1366, they all indicate, although some of them with a marginal error, that the dotted line, if it is to be taken to be 1 kilometer from a center, which is the crushing plant, that line passes well over the development land. But that is in answer to ground 8. But there again, I submit that I am not very certain that, that in my submission, that this is an important point. The important point being not the place, the location of that zone, but the actual existence of the circle. I see I have 2 minutes left.
You've got 4 minutes before the short adjournment.
Yes, for short adjournment.
I don't feel that you have to occupy them.
And I'm just wondering whether that may not be the end of what I wanted to submit orally.
You've covered the ground very well.
I'm much about your Lordship, but perhaps your Lordship can there should be a reply, of course.
And I'm going to invite Mr. Hine whether he wants to follow you.
Yes.
Mr. Hine, do you want to follow? Thank you very much indeed. Do you want to start, Mr. Guthrie?
Well, I can probably start and
Good.
possibly finish.
Good. Good.
Because,
better.
my Lord, when you asked me if I preferred to keep my powder dry, I'm not sure that was a particularly apt metaphor, because I haven't a great deal of powder.
Totally inapt.
Great deal of powder to deploy.
Well, your printed case is commendably brief and to the point.
Well, if I can just digress for a moment, when I first saw the record and I saw the position adopted by the Minister before the Tribunal and before the Supreme Court, I thought I might well be instructed to support the appellant.
Yes.
But I was subsequently instructed that the Minister had not wanted to appeal from the decision of the Supreme Court. So I thought, well, I might be instructed to support the respondent.
Yes.
But as things have turned out, I've been asked to adopt a position of absolutely strict neutrality.
And you haven't been
so,
swayed from that by the argument.
Well, at least I'm not going to make matters any worse.
Thank you very much indeed, Mr. Guthrie.
Can I just say that?
Yes.
I was just, if we're going to come back after lunch, could your Lordship entertain if I have a point which I'm aware of?
Well, of course, we'll consider that, but we may not
much
come
alive.
back after this.
Yes.
Could I just clarify one thing with Mr. Guthrie? Before the tribunal, there was witnesses, particularly Ms. Koo, who had been working with the ministry and had been involved in the preparation of these plans.
Yeah.
But she appeared, I think, as a witness for one of the parties, not...
You appeared for a witness for BSD.
Yes.
Yeah.
The ministry wasn't represented itself.
The ministry did have witnesses. There was a Mr. Hoonam. I think his name is Mr. Hoonam.
Yeah, I see, yes.
But no, the ministry did adopt at that stage.
They were
it defended
supportive.
the grant of the licence.
Yes.
So it was reasonable for it to have done. And indeed, it continued to defend the grant of the licence in front of the Supreme Court.
Yes. But now it's sort of gone back into neutrality.
Yes.
Right, thank you.
There's also Mr. Full, who was a witness called by the ministry.
Yeah, thank you
I
very
see.
much.
Yes. So the
Thank you.
ministry did call witnesses
Yes,
at that point.
Thank you, I haven't got to the bottom of it.
Yeah.
Mr. Susie, do you want to reply?
I can reply in 5 minutes, my lords. So
Yes, let's do that.
Yeah. Lord, just I want to answer to my learned friend Ribot 5 points. First of all, he made reference to ID 4, in fact, at page 2038. And if I may simply extend what he read earlier on, it is at page 20538. So ID 4, when we look at the last but one paragraph, whilst maintaining that it doesn't apply. But if we were to apply, in selecting new sites for bad neighbor developments, locations for more particular facilities, such as landfill and stone crushers, should, where practicable, be planned up to 1 kilometer distant from sensitive land uses, which include residential areas, hospitals, and schools.
Yes.
So I just wanted to highlight that. Also, I just want to once more emphasize on the fact that whenever there is an inconsistency or a difference, that the writing should prevail. And in that case, the policies always speak of up to 1 kilometer. And there is also the fact that before 2006, Your Lordship did put the question, there was a policy 72 which did prescribe for a firm 1 kilometer radius,
yes,
which has been this. And fourthly, if I may, my friend has laid stress on section 24 of the Act, where one must reapply if one wants to challenge. But we say that the buffer zone doesn't depart from the outline scheme, because if there is a difference between the map and the writing says up to 1 kilometer, there is no departure. So there was no need for the appellant to apply to the relevant authorities. The last point, my lords, was in dealing with the map. There was, the map has been handed over to Your Lordship.
Yes,
there
but
was,
take your time.
no, there was the sewerage plant, the only thing, top left, question, goodbye.
Yes.
In fact, my lord, if we look, there are two lines, and if I may refer Your Lordship to page 2070, which is the PPG.
2070.
2070, yes.
70.
It is the Bros, is it?
Yeah.
ST2.
Yep.
And it refers to the second paragraph, my lord. You will see that Saint-Martin sewage treatment works near Bamboo,
Yep.
should conform with criteria of policy ID4. And document BH, the Industrial Development Design Guidance, which is referred to, in fact, Your Lordship will find it at page 2625.
But hang on, just before you leave 2070.
Yes, my lord?
Location of sewage treatment works settlement should be selected using strategic development policies, especially SD3 and 4.
Yes.
The Saint-Martin sewage treatment works near Bamboo, together with its extension, is shown.
Yes.
Buffer zones for all sewage treatment works should conform with the criteria identified in ID4. Now, if they did,
Yes.
they would be something up to 1 kilometre, wouldn't they?
This is where document BH.
And this one is specific.
Yes, indeed.
200 and 400.
Yes.
Well, if that's specific, why isn't the one around the rock crushing plant specific?
Yes. You will have it at document, in document BH, my lord.
BH.
BH, yes, page 2625.
Thank you.
Your Lordships will see that there is a small, two circles,
Yeah.
and you will see buffer zone around sewage treatment plants, zone A. So it is 200 meters, zone A.
Yes.
For nuisance-sensitive uses such as housing, schools, and hospitals, and zone B is notification zone. And this, when you compare to the table on the preceding page, that is 2624, you will see once more that the quarry crushing plant is up to 1 kilometer.
Yes.
So this is the comparison. The other one is a firm.
It's a standard rather than a specific.
Yes.
I've got it.
So this is what I wanted to say, my lords, unless there is... Yes. Il n'y a pas de photo.
My Lords, may I be allowed to?
Lucia may not have finished.
Yes.
No, my little friend Patton is just drawing my attention to the fact that in his address, last part of his address, he did mention the 2011 plan.
Yes.
There is a copy of the plan. Unfortunately, we haven't got copies yet.
Well, if you think it's relevant and there's...
It is.
well, if it is, when copies have been prepared, provided they've been supplied to your opposite number, then we will receive them.
Thank you, Mark.
Yeah. Mr. Rebo.
I'm so sorry.
That's all right.
The BROS 2011, of which my learned friend is making reference, was a modification of the 2006 BROS, but what I wanted to draw your Lordship's attention is that it maintained this data. So that's the first point that I remember. The second point is what I was trying to make as regards the tribunal.
Yes.
This Tribunal Act of 2012
yes.
came to effect in October 2012, and with its members in 2012, and the present case started 1 month after.
I see.
Yeah, so that's the second point I wanted to make, and I'm sure I must have misunderstood my learned friend Patton when he suggested something in regards to the BROS 2001. My point on that is that in the BROS 2001, the one before 2006, therefore, no development management map accompanied. There was no development management.
Right.
That is the point.
Thank you very much indeed.
I'm much obliged, Your Lordship.
I'm very grateful to Council for their very helpful submissions and for those who assisted in the preparation of the printed case. The Board will take time to consider their judgment. The Court is now adjourned.